A Houston area mother fighting to hold a school district accountable after her child was sexually assaulted. It started at James Bowie Middle School. Her mother told KPRC2 her daughter has special needs. The girl is in a program where she must be supervised at all times, but the girl went to the restroom alone on 2 different occasions.
She has an intellectual disability and also a health disability. She has epilepsy.
How old would she be in terms of mental acuity?
I would say 3 or 4. She was sitting on the toilet using the restroom, and a boy crawled under the stall and raped her.
This mom's lawsuit centers around the legal doctrine of state-created danger. KPRC2 investigative reporter Robert Arnold is joining us this morning to discuss what's at heart of this legal battle. Robert, good morning, sir.
You this morning.
Hey, nice to have you. I'm just picking up your mic as we speak. So walk us through, what is the state-created danger doctrine? What is it?
So this is a legal doctrine that can theoretically help a person pierce government immunity. We know that it's very difficult to sue government institutions. When I say government institutions, I'm talking school districts, police departments, cities, things of that nature. Generally, these government entities are immune. However, there is a doctrine called state-created danger, in that it is the state, the government entity, that actually created the dangerous situation that harmed a person. And if successful in that legal argument of state-created danger, it can pierce that government immunity, or what's referred to as qualified immunity, to try and hold a government entity responsible for the harm caused to somebody through what is called this dangerous situation that was created either through inaction or through action, of course.
And so with that said, this mother believes that this applies to her daughter's case.
Yes. And so the way we explained it last night in the story and what is in the lawsuit is this mother says that her daughter was raped not once, but twice by the same boy, a classmate. However, both are special needs students, according to the lawsuit. Both had a plan in place called an individualized education program. That's something that comes from federal law that is required for special needs students. And in this IEP, as it is called, both students were to be supervised at all times. The woman says her daughter was to be supervised at all times, given her intellectual and physical challenges. That's why she needed somebody to be with her at all times. According to the lawsuit, the boy who was in her class was to be supervised at all times because he had a history of violent behavior, again, according to the lawsuit. In the lawsuit, the mother says that there were 2 instances where her daughter was unsupervised in a bathroom at school and she was sexually assaulted by this boy, meaning both were unsupervised during 2 separate incidents. Therefore, she feels that the state did not follow the IEP, which required supervision at all times. Therefore, in her argument, they created the dangerous situation that allowed her to be harmed. Now, her attorney, Joe Alexander, explained that the lawsuit was not filed because of the first sexual assault, that it's almost impossible to prevent a child from being harmed at school by another child. It was the second sexual assault that prompted the lawsuit. And when they found out that there was this requirement that both students were to be supervised at all times, both students were not supervised, which allowed these 2 incidents to happen, according to the lawsuit. That's why they believe that their lawsuit meets this burden, or overcomes this burden of state-created danger, and should pierce that veil of immunity that the school district claims that it has.
Robert, talk to us about the possibility of this going all the way up to the U.S. Supreme Court.
That's because when it comes to state-created doctrine, there's a difference depending on what part of the country you're in. We are in a region that is governed by the U.S. Fifth Circuit Court of Appeals, and the Fifth Circuit Court of Appeals is over Texas, Louisiana, and Mississippi. The Fifth Circuit Court of Appeals does not recognize state-created danger as established law. However, according to the mother's lawsuit, every other circuit court in the United States has at some point recognized the state-created danger doctrine. So it's at odds. So if you file this lawsuit in another part of the country, you have a better shot of piercing governmental immunity. However, here, what's under the U.S. Fifth Circuit, you can't, because the Fifth Circuit has already said we don't recognize state-created danger as established law. So when you have dueling opinions in circuit courts, a lot of times it goes to the U.S. Supreme Court to be the final deciding factor. Now, we don't know if that's going to happen. They've appealed to the U.S. Supreme Court to take up the matter, but we have not yet heard from SCOTUS as to whether it will take up the issue. We're still waiting for that.
Okay, well, we will be waiting. We will be watching. Robert, thank you so much for coming on the show this morning.